The committee will come to order. The pending question is the amendment offered by Mr. Bishop of North Carolina. I recognize myself to speak in opposition to the amendment and to address some of the process concerns that have been raised about this legislation and the record that has been developed in support of it. Earlier this year, the Antitrust Subcommittee held a hearing on reviving competition, where it examined recommendations to address gatekeeper power and lower barriers to entry online. Longtime antitrust attorney John Thorne testified that Congress should enact legislation to clarify that antitrust cases brought by states cannot be transferred by the Judicial Panel on Multi-District Litigation. Mr. Thorne expressed concern that the transfer of state antitrust litigation slows down enforcement by state attorneys general. These delays impede the ability of state attorneys general to protect their citizens from monopoly power. In May, Senators Amy Klobuchar and Mike Lee introduced a companion to this legislation. Senator Klobuchar explained that this bipartisan legislation will allow for more efficient and more effective antitrust enforcement by state attorneys general, which is good for competition and consumers. Senator Lee explained that federal antitrust enforcers already benefit from protection against delays or threats from private antitrust suits, and there is no reason that state attorneys general should not receive the same protection. He concluded that this bill will strengthen federalism by putting state antitrust enforcers on an equal footing. As was noted previously, earlier this month, 52 state and territorial attorneys general wrote to the committee to urge us to enact this bill. This legislation enjoys significant bipartisan, bicameral support, and I encourage my colleagues to support it. I yield back. And who seeks recognition? If no one seeks recognition, who
Move to strike the last word.
gentleman is recognized.
Thank you, Mr. Chairman. I would urge my colleagues to vote no on this amendment. This bill is a procedural bill to promote antitrust enforcement, and this is not a substantive bill. In every antitrust case, there is a trade-off between limiting the burden on the accused defendant versus expediting enforcement. Congress discussed that trade-off in preventing JPML interference with DOJ antitrust cases. Deputy Attorney General Ramsey Clark explained inclusion of United States enforcement actions in complex multi-district proceedings would almost certainly cause substantial delay for the government's enforcement. In passing Section 1407G, Congress was aware that keeping United States antitrust actions separate from multi-district proceedings might occasionally burden defendants by requiring them to answer similar questions posed by both the government and by private parties. But permitting United States antitrust actions to remain independent was justified by the importance to the public of securing relief in antitrust cases as quickly as possible. That exact same principle applies here. The importance to the public of securing relief in antitrust cases as quickly as possible is equally true for state cases as it is for the cases brought by the United States. The states should get the same procedural ability to file in a faster court without the drag of being joined with private cases that have, one, different incentives, and two, lack the pre-complaint investigation that makes state cases faster. Before I yield back, I would remind everyone here that your state AG signed a letter supporting this bill in its current form. They are the ones on the front lines and know what they need. They think this is a good bill as drafted. Additionally, Senator Mike Lee and Senator Klobuchar introduced an identical bill in the Senate. Senator Lee is obviously supportive of the bill as is because we decided to introduce this bill as is. This is a simple procedural bill that is good policy. Mr. Chairman, I yield back.
The gentleman yields back. Who else seeks recognition? For what purposes Mr. Roy seek recognition?
Move to strike the last word.
Gentleman is recognized.
It is rare that I come to a different conclusion than my friend from North Carolina, so it gave me pause, which I discussed and called some of my friends back in the Office of the Attorney General, where Chairman will remember I was the first Assistant Attorney General, so I talked to the Antitrust Division, trying to understand how this would play out and how it would work, and my conversations with them, and ultimately why, and I'll talk about the bill, the underlying bill in a minute off of this amendment, but on this in particular, he reminded me, and I was thinking through this, the federal enforcers here don't get a carve out for big tech. And so in this case, I just think all this does by adding in or state is aligns that incentive and gives states the ability and the power to do what the feds are doing. And for that reason, I will oppose my friend's amendment.
Gentleman yield back? Does the gentleman yield back?
Right, you want to yield back? Yield back.
Gentleman yields back. Does anyone else seek recognition? In that case, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no? No. In the opinion of the chair, the noes have it.
Mr. Chairman, I ask for the yeas and nays.
The yeas and nays are requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen?
No.
Mr.
No.
Cohen votes no. Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Ms. Bass?
You need to unmute.
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes no. Ms. Escobar? Mr. Jones? Ms. Ross? Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no.
Mr. Chairman,
Jones?
how am I recorded?
Mr. Jones, you're not recorded.
Jones votes no. Mr. Chair, how am I recorded?
Mr. Neguse, you are not recorded.
Neguse votes no.
Mr. Neguse votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat? Aye. Mr. Shabbat votes aye. Mr. Gomert? Mr. Issa? Mr. Issa votes aye. Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? Mr. Benz? Mr. Benz votes aye. Mr. Owens? Mr. Owens votes no.
Mr.
Mr.
Chairman, Ms.
Raskin?
Raskin, am I recorded?
Mr. Raskin, you are not recorded.
I vote no.
Mr. Raskin votes no.
Mr. Chairman, how am I recorded? This is Rep. McBath.
Ms. McBath, you are not recorded.
I vote no.
Ms. McBath votes no.
Mr. Correa?
Mr. Correa, you are not recorded. Mr. Correa votes no.
Mr. Chairman,
Ms. Escobar?
I vote no.
Ms. Escobar votes no.
Mr. Deutsch?
No.
Mr. Deutsch votes no.
Is every member who wishes to be recorded recorded? The clerk will report.
Mr. Chairman, there are 11 ayes and 31 noes.
The amendment is not agreed to. Are there any further amendments? In that case,
Mr. Chairman?
Mr. Roy,
Yeah, move strike last word.
gentleman is recognized.
I want to only add to what I was saying before, and after talking with the folks that I worked with in the Antitrust Division, the AG's offices, and obviously we've got 52 AGs in support of this, that for those who have concerns about it, that it very simply adds "or state" into the text to draw parity and empower state AGs to be able to engage in this, and I think that is an improvement across all areas of in industries, and therefore support the underlying bill. I thank you, Chairman. Yield back.
Gentleman yields back. Are there any further amendments? In that case, the question occurs on the amendment in the nature of a substitute. All those in... This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no. In the opinion of the chairs, the ayes have it, and the amendment is in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 3460 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
Aye.
The ayes have it, and the bill is ordered reported favorably.
Mr. Chairman, I request a recorded vote.
A recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee?
Aye.
Ms. Jackson-Lee votes aye. Mr. Cohen?
Aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass?
Aye.
Ms. Bass votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye. Ms. Stemmings? Ms. Stemmings votes aye. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Mr. Neguse? Ms. McBath?
McBath votes aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Mr. Jones?
Jones votes aye.
Mr. Jones votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan?
Mr. Chairman, how am I recorded? Raskin?
Mr. Raskin, you are not recorded.
I vote aye. Thank you.
Mr.
Mr. Chairman, how am I recorded? Neguse?
Mr. Neguse, you are not recorded.
Neguse votes aye.
Mr. Neguse votes aye.
And how am I recorded?
Ms. Scanlon, you are recorded as no.
That was supposed to be aye. Thank you.
Ms. Scanlon votes aye. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Issa? Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fischbach? Ms. Fischbach votes no. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes yes.
Has everyone who wishes to vote voted?
Mr. Issa, you're not recorded. Mr. Issa votes no.
Anybody else? The clerk will report.
Mr. Chairman, there are 34 ayes and 7 noes.
The ayes have it, and the bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 3849, the Augmenting Compatibility and Competition by Enabling Service Switching Act of 2021, or the Access Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3849 to promote competition, lower entry barriers, and
Without
reduce.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 3849, the Augmenting Compatibility and Competition by Enabling Service Act, or Access Act, requires dominant online platforms to provide competing platforms the ability to connect and communicate with their systems, a concept known as interoperability, and requires these dominant platforms to allow users to transfer their data to another competing platform, which is known as data portability. Too often, the segments of the digital economy that are dominated by the largest platforms are closed off to competition. These markets often have high barriers to entry, switching costs, and other characteristics that lock in consumers and businesses to using one company in that industry. These market characteristics also reinforce the dominance of powerful firms while blocking new entrants into the market and depriving consumers and small businesses of choice. The Access Act of 2021 addresses these concerns by giving the Federal Trade Commission new authority and enforcement tools to establish pro-competitive rules for interoperability and data portability online. To do so, The bill creates a technical committee inside the FTC comprised of relevant businesses, agencies, and experts to develop these standards for adoption by the FTC. The Access Act also gives the FTC new authorities to swiftly challenge abusive conduct that violates these interoperability and portability requirements. Importantly, the Access Act also protects user privacy and data security. The bill empowers users to determine how and with whom their data is shared. It also requires data minimization for firms interoperating under the bill so that companies do not monetize, collect, or use more data than is necessary. Throughout its investigation, the Antitrust Subcommittee heard testimony from several witnesses about the benefits of interoperability and data portability, which are well-proven tools to promote competition and break down barriers in highly concentrated markets. Congress relied on these same tools in the Telecommunications Act of 1996, which required the regional Bell operating companies to interconnect with rivals and required them to allow consumers to take their phone numbers with them if they switched to another phone company. This bill strikes the right balance to encourage competition, give consumers more choices, and protect user privacy. I thank my colleagues, Congresswoman Scanlon and Congressman Owens, for their leadership on this important bipartisan measure, and I urge its adoption. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This bill creates secret advisory committees. I want to stress that. Page 18 of the amendment in the nature of the substitute, bottom line 21, non-applicability of the Federal Advisory Committee Act. The Federal Advisory Committee Act shall not apply with respect to the technical committees. So each of these technical committees, for every single one of the covered platforms, covered companies, we don't know what goes on there. We're not allowed to know what goes on there because the law that normally applies to any advisory committee has been waived for this legislation. If that's not bad enough, this structure could jeopardize those companies' data security, making them more vulnerable to hacking and illegal surveillance. The idea of data being portable and interoperable is something that sounds great, and frankly, something I think most of us would like to get to, figure out how to do this right. It's something that has broad support. This bill's treatment of the issue, however, is absolutely unworkable. For starters, there is ambiguity about the definition of data that will give broad discretion to the regulators. In other words, a bill about data never directly defines data. Instead, the bill tells the FTC to do it. We should do that. We write the laws, they regulate. We shouldn't give that authority to them. Talk about a blank check for big government regulators. The so-called advisory committees that this bill sets up would include, quote, representatives of competition or privacy advocacy organizations, end quote, independent academics. Under the bill, the committee size, as I said in my opening statement, and its membership are also within the sole discretion of the FTC. So what does that all mean? There's nothing in this bill to prevent any number of left-leaning groups from getting a seat at the table to direct how data practice would work, or frankly, potentially right-leaning groups. They might be concerned about that. We don't know, and we never get to see how they operate, what these technical committees do. That's a lot of power. And what happens if the companies run afoul of this act or their regulations, or its regulations? The government can take up to 15% of their total revenue and all of their CEOs' pay or the pay of any other corporate officer. And we may think that's great. We want to get these guys. If they do something wrong, we want to get them. But what that, I think, means in practice, the CEO's not going to lose his whole pay or her whole pay. They're not going to want to give up 15% of total revenue. They're just going to say, what do you want us to do, government? Government-run companies is what we're talking about. And I talked a lot about this in the opening statement when we started at 10:30 this morning. But my other big concern about this is privacy. What this means something we all should care about as members of the Judiciary Committee, members who care about privacy rights, the Constitution, the Bill of Rights. I'm very nervous about that as this bill is currently drafted. With that, Mr. Chairman, I would yield back.
Gentleman yields back. I now recognize the chair of the Subcommittee on Antitrust, Commercial, and Administrative Law, the gentleman from Rhode Island, Mr. Cicilline, for his opening statement.
Thank you, Mr. Chairman. H.R. 3849, the Access Act of 2021, creates interoperability and data portability requirements for the largest online platforms. Interoperability and data portability will encourage new competition in digital markets by lowering barriers to entry for new firms and lowering switching costs for consumers. The high levels of concentration in segments of the digital marketplace can be attributed in part to network effects. data advantages, and economies of scale and scope that advantage the largest platforms. New competitors often face daunting barriers to entry. Consumers face high switching costs. Some markets become winner-take-all, locking in the dominance of a few firms and blocking new entrants from meaningfully competing. The Access Act, introduced by Congressman Scanlon and Congressman Owens, helps address high levels of concentration online and creates new opportunities for competition. The Access Act requires dominant platforms be interoperable with other businesses. It also empowers users of dominant platforms to take relevant data to another service. Data portability will empower consumers to switch to other services more easily. They will not have to start over. They will not lose access to their list of friends, photos, communications, or seller ratings when they switch from one social network, e-commerce platform, or mobile operating system to another. For example, a small business selling on Amazon will be able to take its customer reviews and other information to use it on its own retail website or on a rival e-commerce platform. An iPhone user would not lose access to her prior communications simply because she switched to an Android phone. New competitors in these markets will have a better chance to convince users to switch. They will be able to compete by offering better prices, higher quality, or more privacy. It's the very essence of competition. Interoperability will ensure consumers do not have to choose between communicating with users of the dominant platform and migrating to a platform that better serves their needs. Interoperability opens new opportunities for competition. As a result, we'll have a more dynamic digital economy, and consumers will have more choices. Interoperability and data portability are not without challenges, and that's why the Access Act directs the Federal Trade Commission to establish technical committees bringing together industry, government, academic, and other experts to help design interoperability that works. The key is to get it right so that interoperability requirements under this bill effectively promote competition and reduce the need for government oversight and intervention. This bill also includes enforcement mechanisms to deter dominant platforms from undermining the interoperability and data portability requirements. Additionally, the Access Act includes strong safeguards to protect privacy and security. Any transfers of data from one business to another under this bill may only occur at the express direction of the user. Online firms are required to minimize the data they use and share to make services interoperable. By opening up new opportunities for competition, the Access Act promotes new investment and innovation. Small businesses and startups will have more opportunities to attract users. Rather than resting on their laurels and relying on their ability to lock consumers in, the dominant platforms will have to rededicate themselves to improving their products and keeping their users happy. They'll have to compete in a more dynamic marketplace, spurring more investment and more innovation. Consumer and public interest advocates at Consumer Reports, Public Knowledge, the Electronic Frontier Foundation, and New America's Open Technology Institute have all called for interoperability requirements as a way to promote more competition online. I agree with them. This is important and common sense legislation. Consumers will benefit. They will have more choices. They have more access to more products and services that compete on metrics such as privacy, quality, and security. I want to thank Congressman Scanlon and Congressman Owens for their leadership on this issue. I encourage my colleagues to support the Access Act, and I yield back.
The gentleman yields back. I now recognize the ranking member of the Antitrust Subcommittee, the gentleman from Colorado, Mr. Buck, for his opening statement.
Thank you, Mr. Chair. The Access Act will create consumer-oriented data portability and interoperability policies to further facilitate competition in the marketplace. Perhaps one of the most popular and pro-competitive actions Congress ever took was mandating mobile phone portability in the Telecommunications Act of 1996, authored by Newt Gingrich. Consumers were empowered to shop between carriers without having to worry about changing numbers. The result was a competitive and pro-consumer marketplace that Americans take for granted today. Unfortunately, pro-monopoly lobbyists have embarked on a massive disinformation campaign against this legislation. For this reason, I want to spend my time debunking their misinformation campaign. First, this bill will not create additional data security and privacy concerns for covered platforms. In an attempt to keep precious user data firmly in the hands of big tech, their lobbyists have conjured the specter of data theft and privacy breaches, even though Sections 3B and 4B clearly mandate those other businesses have security and privacy measures in place to protect consumer data. Section 4B3 also allows for terminating a business's data access in the event of security or privacy violations. It's interesting that big tech now cares about data security and privacy. Just this year, it was reported that the personal information of over 533 million million Facebook users from 106 countries, including over 32 million records on users in the US, 11 million on users in the UK, and 6 million on users in India, was stolen. The data in this tranche of stolen information included users' phone numbers, Facebook IDs, full names, locations, birth dates, bios, and in some cases, email addresses. In 2019, Facebook was fined $5 billion for privacy violations. It seems like data privacy and security were not much of a concern for big tech until their monopoly was on the line. Second, this is not a big government bill. Big tech and their lobbyists claim that this legislation will give more power to the federal government to pick winners and losers. It does the exact opposite. It changes the law so that big tech, who became monopolies solely because of favorable government policies, no longer have a vice grip on Americans' data. Consumers get to choose who has their data, and that has Google and Facebook very worried. We're kicking their $300 billion wasp's nest. It's no surprise they're fighting to keep the status quo in place. Section 3A requires big tech work with any business user who wants to compete so that consumers can move their data around when they want to. No data moves until the consumer makes an affirmative choice. Additionally, the bill doesn't list who the competing businesses are that big tech must work with. It leaves that to the market. Third, it does not create new opportunities for companies controlled by China or other foreign actors. Apple and Google have already let the fox in the proverbial henhouse because they have TikTok and Alibaba available on their respective app stores and interfacing with their operating systems. If these companies actually cared about not letting Chinese companies into our digital marketplaces, those two apps wouldn't be available to U.S. consumers. Fourth, another argument against this bill is that it is somehow Chinese or European in origin or inspiration. Our K Street friends point to the Gdpr data portability requirement as proof that this is somehow importing European competition law and policy into the U.S. The European got their ideas from us, not the other way around. Data portability and interoperability are American ideas. Both concepts were in the 1996 Telecommunications Act that was passed under Speaker Newt Gingrich and Senate Majority Leader Bob Dole and signed into law by President Clinton. On the China front, I can't make much sense of how someone acting in good faith could say this bill imports a Chinese model into our laws. The national champion model that big tech backs, where regulators single out favored firms for special treatment, is the Chinese model. In China, there is one giant company for every sector, like Alibaba for e-commerce or Huawei for telecommunications. That is the model Facebook and Google want because it cements their monopolies. Next, we have the argument that liberals like Madison Cawthorn, Burgess Owens, Lance Gooden, and I say liberals, tongue-in-cheek, and me, are unwittingly turning over the keys to regulate the entire U.S. economy to Lina Khan and the Biden administration. Supposedly, there is text in this bill that has yet to be identified or cited, for that matter, where we are turning over sweeping rulemaking authority to the bureaucrats at the FTC and therefore turning over the reins to the American economy to the progressives in the Biden administration. This one is deserving of a 5 out of 5 Pinocchio rating. First, the rulemaking authority granted in Section 6C is limited by the very text of the bill to rulemaking only for the purposes of implementing Sections 3 and 4 of this bill. By the very words of the bill, we are not granting general rulemaking authority. The text is very narrowly tailored. And lastly, we have the secret committees specter. The general gist of this argument is that we are authorizing secret technical committees that will help the FTC come up with secret standards that no one knows about until they spring forth from Lina Khan's FTC to haunt all American businesses forevermore. This is obviously not happening. Under Section 6C, the Commission must issue the standards recommended by the technical committee. The secret technical committee doesn't get to set the terms big tech will have to live by. The Commission, the Federal Trade Commission, whose votes are on the record and who are accountable to us here in Congress, must ultimately choose what the standards are. In summary, when you look at the bill, at what the bill actually says, instead of listening to the hysterics of well-paid obfuscators, you will see that this bill is very thoughtful in its approach and is narrowly tailored to address just the concerns the bill seeks to address. Mr. Chair, I request unanimous consent to enter into the record the following documents. A September 2019 white paper by, I apologize, I won't offer those. I yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3849, offered by Mr. Nadler of New York. Strike all after the enacting clause.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment in the nature of a substitute makes several revisions to improve the bill. To better effect the goals of the bill, the amendment replaces the term competing business or potential competing business with the term business user. In Section 5 of the bill, the amendment defines the required affirmative consent in terms of users rather than consumers to provide additional clarity. The amendment also makes technical changes to Section 6 of the bill to clarify when and how the agencies may remove a covered platform designation. In Section 7, the amendment provides additional clarity about the role that a representative of the covered platform may have on a technical committee. Finally, the amendment makes additional technical and conforming changes in Section 8 to clarify the scope of judicial review. All of these provisions improve an already good bill, and I urge all members to support the bill, to support the amendment. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute?
I'd move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, thank you. And thank you, Ranking Member Buck, for your remarks debunking some of the myths that have been promoted about this bill. During our 7 hearings, the extensive briefings and document review that the ACAL subcommittee conducted over the last year and a half, we developed a record to reflect what most Americans know from personal experience. For too long, the largest online platforms have dominated key parts of the digital economy, acting as gatekeepers to stifle competition while compromising online user privacy and quality of service. We've seen the tech giants take advantage of a phenomenon known as network effect, which occurs in which the increase in the number of users of a service increases its value. The strong network effects of firms such as Facebook and Google have made it all but impossible for users to switch to competing platforms if they're unhappy with their service. Regardless of the quality of service, a user whose entire network is on Facebook can't simply switch to another social media platform that none of their friends use, and a new social media platform will struggle to attract new users for this very reason. While theoretically a consumer could simply leave a covered platform if they're unhappy, the services these firms provide have often become too ingrained in everyday life for that to be a real option. In other words, these huge platforms have monopolized the conversation. Facebook and Google, for instance, offer space for minority groups to organize and connect, for parents to get information about school closures or COVID-19 updates, and for small businesses to bring in customers. But the growing dominance of these firms in the digital marketplace has come with serious downsides, and it doesn't mean that they are the only or the best possible platforms for users to access vital services. In a truly competitive landscape, we might expect the best companies would rise to the top. The strong network effects of the dominant platforms, however, have perverted this expectation in the digital marketplace. We know this because many users are unhappy with the costs associated with using these platforms, often being forced to compromise their privacy, their data, or their ethics to participate online. A mom or dad organizing a bake sale or soccer practice online may prefer to do so on a platform that doesn't expose them or their children to misleading advertising. But doing so is near impossible because of a notable lack of competition in the digital ecosystem. Without meaningful competition, there's little incentive for firms like Facebook and Google to respond to users' privacy and platform quality concerns. And there are few, if any, competing firms for Americans to turn to when these companies drop the ball. That's why I, along with my colleague, Congressman Owens, introduced the Access Act. This bipartisan, bicameral bill promotes competition online by disrupting network effects and lowering switching costs for consumers and businesses. The bill establishes data interoperability and portability requirements for dominant firms, thereby allowing new entrants to compete more effectively online and giving users meaningful choice by ensuring that they can easily move their data to competing services. Much like texting allows iPhone owners to communicate with Android owners, so too would this bill allow individuals switching to new social media platforms to be able to communicate and interact with their friends and family on Facebook. For startups and small businesses, this would be a game changer. Small businesses could capture and store important data such as their Google reviews or Amazon sales numbers and take this information with them if they're unhappy with platform quality. Consumers would also find themselves emboldened and better served by increased competition. The mom or dad organizing the bake sale or soccer team could do so on a platform that relies on a business model free of ad revenue or one that works harder to prevent the spread of misinformation. The bill also provides meaningful protections for user privacy, a priority for me and my colleagues on the committee. Businesses that choose to interoperate with covered platforms would have to meet the same security and privacy standards as the platforms themselves, and the FTC would oversee the creation of a strong privacy standard to protect user data. No longer would these companies be the only kids on the block. Instead of squeezing out competitors, they would have to compete for users, and consumers would have more choices if they found platforms coming up short. Big tech companies have convinced us that anti-competitive tactics and degradations in user privacy are just the cost of doing business, that to have access to great products, we just have to settle. But this bill rejects that premise. This bill said, let's do away with some of those barriers to entry and allow online competition to flourish. If better platforms arise from this legislation, then great. If Facebook or Google step up their service in response to competition, that's also great, because in the end, consumers and small businesses will benefit from the additional choice. And that's what this bill is about, to give Americans the freedom to have a real say in the online platforms that work best for them and their families. I urge my colleagues to consider this legislation and to vote yes to advance it through today's markup. With that, I yield back.
Gentlelady yields back. Who else seeks recognition? Mr. Jordan, for what purpose do you seek recognition?
Strike the last word, Mr. Chairman.
The gentleman is recognized.
Thank you, Mr. Chairman. I just wanted to, my good friend from Colorado said that earlier that there are no secret committees in this legislation. I just beg to differ. If the technical committees in this bill aren't really secret, why do they operate in secrecy? Again, I'll read from the legislation. Page 18 of the amendment in the nature of a substitute, non-applicability of the Federal Advisory Committee Act. The Federal Advisory Committee Act shall not apply with respect to these technical committees. So what does that mean? Normally, when you have the Federal Advisory Committee Act applied, there's notice of meetings, there's a notice of who's on the committee, the meetings are open, records are subject to inspection, but that doesn't apply. So somehow you can all say that's not secret committees, but that sure sounds like a secret committee. If normally when there's an advisory committee created by the Congress, they have to notice the meeting, tell you who are the members of the committee, when they're going to meet, you can go to those meetings, and the records are subject to inspection. Obviously, with the trade secret information, that wouldn't go public. I get that. But to say that there's no secret committees, when in fact it specifically says there are secret committees in the legislation itself. So first, we're giving the FTC more money. We offered several amendments to limit the amount of money or where the money can be used, how it can be used. And now it's, nope, we can't do that. They're going to get more money. We can't limit how it's spent. And oh, they get to use that money to operate in secret. Such a deal. Such a deal for the taxpayers. And nowhere in there do we address the concern that I think most of the folks I get the privilege of representing in the 4th District of Ohio care about, which is censorship by big tech of their First Amendment liberties, of their speech. So that's my concern with this legislation. That's why I referenced it in my opening statement, as I said several hours ago. There are secret committees in here because the legislation says so, and it specifically says the law that we put, that Congress has passed at some point, which says that you shouldn't have advisory committees that aren't subject to some kind of open transparency, specifically doesn't apply.
Gentleman yield.
Be happy to yield to my friend.
I'd ask the gentleman, why don't we just move or have an amendment to strike the language on page 18, lines 21 to 24, and take care of that issue. There won't be secret committees if we do that.
Well, I certainly support that amendment, but I was responding, if reclaiming my time, I was responding to what you said. You said there are no secret committees, and I'm like, it's right there. Now you want to get rid of the language to get rid of the secret committee. So it can be both. That's what I was responding to. If you want to offer that amendment, I'd be happy to support it from my good friend from Colorado. With that, Mr. Chairman, I yield back.
The gentleman yields back for what purpose does the gentlelady from California seek recognition?
To strike the last word.
Gentlelady is recognized.
I want to thank Congresswoman Scanlon and Mr. Cicilline for identifying interoperability and portability as a very important item. That can give users fundamental control over their personal data when otherwise it would be locked away and de facto owned by private companies. Ultimately, this gets to a central privacy right that each of us should have meaningful control over how our personal information is stored, used, and shared. Here, privacy rights aren't just about keeping information out of public view, they're also about users being free to share and use their data with others as they choose. For these reasons, portability and interoperability are policy goals I have long supported, although portability and interoperability are not the same. For example, in the Online Privacy Act, which I introduced with Representative Eshoo last year, we included extensive authority for a new data agency to require different online services to give users the power to make their data portable and interoperable, at least when merited by the nature of the data and service, and thus I strongly support the overall goal of this act. However, I must note that I do have substantial concerns with some of the provisions of the bill as drafted. Importantly, we need to make sure that the bill contains the necessary safeguards to privacy and security risks from interoperability and portability. In order to achieve these goals, platforms must open up their systems and user data to third parties, and while this can be beneficial to both users and to competition, the risks from abuse or neglect of the technical details are quite obvious. Some of the biggest privacy scandals of the last decade, including Cambridge Analytica's debacle of the mass scraping of Facebook data without users' consent, were essentially the result of insecure schemes for portability and interoperability. At any time one app or device communicates with another, and especially when it involves the transfer of sensitive information, there can be privacy and security risks. I acknowledge this bill does contain some provisions obligating the FTC to write standards to address these issues. However, I believe these mandates need to be clearer and more detailed in several respects in terms of what the FTC must do to ensure the interoperability required in the bill does not harm users or platform security. Here's the underlying issue. Most past proposals on platform portability and interoperability have been just one part of a larger piece of privacy legislation. That's the approach we took in the Online Privacy Act. Setting forth a larger framework of privacy guarantees and enforcement is probably the only way to fully address this issue. That said, if we're going to mandate platform interoperability and standalone legislation through the FTC, we must at least include a minimum set of robust privacy protections. Unfortunately, given the speedy nature of this process and both the legal and technical complexities of these challenges, it's not been possible to fix this concern prior to today. However, one of the amendments I intend to offer to the Access Act would at least address a core problem in the bill as drafted involving interoperability and user consent. Now, regardless of the outcome on either these or the other amendments I intend to offer, the work on privacy and security issues in the bill will, I'm sure, continue. Ms. Scanlon is right. The big platforms have all your information, and if you can't move it, then you're really a prisoner of that platform. Who wants to leave a platform if they've got all your baby pictures and all of your videos of your grandchildren locked up? So although the big platforms now provide for portability, the principle of it is sound, but the privacy for interoperability needs to be enhanced. I look forward to working with Congresswoman Scanlon and Chairman Cicilline and any other members to address these concerns. And I'm hopeful that we can ultimately craft a solution that gives users more control over their personal data that will boost competition, which I believe in, and will also protect privacy, security, and the legitimate business and technical interests of the platform. And I see that my time has expired, so I would yield back, Mr. Chairman.
Gentlelady yields back. For what purposes Mr. Biggs seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. It was said this morning that a monopoly will fail if it doesn't satisfy its customers, and that's true. But a monopoly may also enhance its staying power by engaging in unfair business practices. Even the great Austrian economist Friedrich Hayek suggested that markets work when the players are engaged in fair competition. For instance, we provide enforcement institutions and regimes to deal with issues such as fraud or tortious conduct to keep our markets fair. Almost 130 years ago, a movement was undertaken to cure inequities in the market. The remedies were undertaken to particularly address barriers to entry and unfair competitive practices. Yes, a monopoly may develop because of environmental conditions, first out of the box, development of increasing return factors, etc. But if a business rises to a position not just as a dominant player, but in a monopolistic position through unfair practices designed to crush competition and inhibit barriers to entry, then there's a limited role for government to intervene on behalf of society, consumers, competitors, entrepreneurs. We have reached the point where big tech companies regularly have obtained and maintained a monopolistic position. These companies have crushed competitors, prevented entrepreneurs from entering the field, used their power positions to stifle voices of individuals, exceeding the scope of a normal platform. They have undertaken demonstrably to censor certain viewpoints, particularly conservative viewpoints. Judicial proceedings concerning unjust treatment of business and individuals will not obtain due process because these big tech companies can crush a plaintiff in discovery proceedings. Normal market forces will not bring this back to balance. These companies need to be reined in and frankly should be dismantled. Each of the four substantive bills that we're considering are rooted in strong soil, but each is also in danger of succumbing to assorted weeds and brambles. In this particular bill that we're considering, on page 17, one of my concerns is it says that a failure by the covered platform to participate in good faith in the development of standards by the technical committee shall be a violation of this standard. I would suggest to you that a covered platform required to participate as large as these are may actually try to take over that technical committee. That is a concern I have. What makes that a concern particularly is on page 18, line 15 through 20, when it says the role of a technical committee established under this act is advisory in nature. That seems appropriate. And such committees shall have no implementation or enforcement authority. I agree with that position. However, the Commission shall give strong consideration to the recommendations of such committee in implementing this act. What does strong consideration mean? How is it visible? How is it interpreted? Particularly in light of the fact that I agree with my friends, Mr. Jordan and Mr. Buck, that maybe lines 21 through 24 should be modified. But how does that deal with it? Should you get the situation where it is closed door, you can't see what's going on, and one of these big bad actors, and I do believe they are bad actors, tries to manipulate that system? I am concerned about that. I thank the folks who've participated in putting this together. I do believe that to solve these issues, including the issue that the ranking member mentioned, which is paramount in the minds of my constituency, and that is the unfair censorship of conservative voices by these tech oligarchs. I do believe that the best way we're going to find to resolve that issue is to attack them through the antitrust laws. And so I appreciate the effort to try to craft laws that work. I just want to make sure they do work if we're going to engage in this. And with that, Mr. Chairman, I will yield back.
The gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
I'll just strike the last word.
Gentlelady is recognized.
If I place myself in the shoes of an ordinary consumer, and certainly one that has been either both plagued and benefited from the amazing tech revolution, I can assure you that one of the elements of their concern is the ability to protect their data and to have flexibility in the device service that they use. So I want to thank Congresswoman Scanlon and Congressman Cicilline and the committee, Mr. Nadler, for a very utilitarian legislation, and the Republican co-sponsor as well, Mr. Owens, because the idea of being able to augment compatibility and competition for enabling service switching access is an idea long overdue. I do think it's important as well to ensure your protected privacy. But there's social networking going on with consumers as young as probably 4 years old, e-commerce, app stores. Wasn't there Prime Day just Monday or Tuesday of this week? Maybe it's still going on. One of the things that I think is noteworthy is that all of the use that our devices are subjected to, they are inescapably put into the public sphere with susceptibility to cyber hacking. And so as we look at this legislation, I want to be concerned about and ensure that we continue to focus on that as we are able to move our data from one place to the next. The digital economy, strong network effects, and high switching costs often result in a winner-take-all markets, locking in the dominance of some firms while blocking new entrants from contesting these markets. In the middle of this, of course, are the consumers. The Access Act is a catalyst for competition, requiring that dominant online platforms are interoperable with other services and gives users more choice online by allowing them to move their data to a competing service. H.R. 3849 promotes competition online by lowering barriers to entry and switching costs for businesses and consumers through interoperability and data portability requirements. H.R. 3849 is similar to the interconnection and phone number portability requirements under the Telecommunications Act of 1996, pretty long time ago. But under H.R. 3849, coveted platforms are required to maintain interfaces to facilitate portability of user data and interoperability with competing businesses. I'm always reminded of the importance of protecting the data of consumers who don't have their own infrastructure to do so. I think it's important to comment on these various tech committees, because the legislation charges the FTC to oversee the process, including establishing platform-specific standards and setting up technical advisory committees to assist in the standards-making process. I want my good friends to know that I don't believe these are FISA courts. These are committees that have a logistical and mechanical responsibility, and that is that they help with the standards to ensure that the bill or the legislation works, that data can be switched, that the consumer is protected, and to review when there is a need to improve that. They assist in the standards-making process. I don't think you can say they do any more or do any less. And to suggest that there might be some hidden agenda, I think we can only assume that they are simply working to make sure that the consumer is protected with the right kind of standards. Finally, the legislation also includes privacy safeguards for user consent, data minimization, and requires the FTC to include privacy and security guardrails in the interoperability and portability standards it develops and issues. These are ongoing efforts. Privacy always requires enhanced review. It always requires responding to new technology and, of course, the capability of those who are intent on criminal activities, use ransomware, and to undermine either Colonial Pipeline or any other entity, including consumers. So I support this legislation, look forward to its passage and our continuing work in this committee on these efforts. With that, I yield back.
The gentlelady yields back. For what purpose does Mr. Buck seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 3849, offered by Mr. Buck of Colorado. Page 18,
Amendment
strike
will be
lines.
considered as read. The gentleman is recognized.
I thank the chair. This is the amendment that I mentioned a moment ago with Mr. Jordan. It moves, on page 18, it moves to strike lines 21 through 24, and in their place, adds a reporting requirement, which is something that I heard from a number of members that they felt strongly about, that we should have a reporting requirement. So I don't believe that the lines make this a secret committee any more than to say that our bills, for example, in Congress are drafted in secret. The fact that
It's a traffic emergency alert. I withdraw my point of order, by the way. It did.
So, as I was saying, this amendment moves to strike this language and add a reporting requirement. It's very simple and straightforward, and I ask for members' support on it.
Gentlemen, yield?
I will yield, yes.
So I just want to be clear. In the draft of the bill prior to this amendment, before this amendment, the current draft of the bill, are there secret committees?
In my view, they're not secret because any action that the committee takes needs to be approved by the commission.
Well, then why do we need your amendment? I mean, a little bit ago, 15 minutes ago, if the gentleman would yield, 15 minutes ago, you said you want to debunk certain false statements made earlier. 15 minutes ago, you said that. Now, all of a sudden, you need an amendment. Even though you said there's no secret committees there, now you need an amendment to take out the language that actually says there are secret committees because it says the Federal Advisory Committee Act does not apply, which means no notice, no open meetings, no records subject to inspection, and no notice of who the members are of this secret committee. So which is it? Is there a secret committee or there not a secret committee?
There's not a secret committee, but to address your concerns, Mr. Jordan, I am offering this amendment to strike the language so that this won't be an issue in gaining support for this bill. And I yield back.
Mr. Chairman, I'd move to strike the last word.
Gentleman yields back. For what purpose does,
I'd move to strike the last word.
well, gentlelady's recognized.
Thank you. As I understood Mr. Jordan's objection, it was to the language indicating that the certain act did not apply.
Federal Advisory Committee Act.
Yes, Federal Advisory Committee Act. And in fact, that only applies to fully government committees, and this is a partially government committee and also partially private actors. So I thank Representative Buck for this amendment. I completely agree that transparency should be a pillar of any comprehensive legislation. And I think this amendment will help Congress to understand the positive impacts of the Access Act and allow us to better oversee implementation of its provisions. So I plan to vote in favor of this amendment and would encourage my colleagues to do the same. With that, I yield back.
Does anyone else want to speak on this amendment? Mr. Massey?
Yes. Move to strike the last word.
Gentleman's recognized.
I'm glad we're talking about transparency here because I'm trying to figure out why one of the biggest offenders, big tech, has mysteriously evaded the scrutiny of this committee and this broad swath of bills that seek to radically rewrite our antitrust law. I'm talking about Microsoft. Is anybody here concerned that on behalf of the Communist Party, Microsoft censored Bing search engine results of Tank Man on the anniversary of Tiananmen Square protests, including results for users in the United States, and has muzzled the voices of China critics on LinkedIn? We need transparency. LinkedIn also has restricted accounts for posts related to COVID-19, citing its misinformation policy. LinkedIn censored posts that the coronavirus originated from a dangerous laboratory in Wuhan, China. And finally, well, there are lots of examples, for one of the biggest tech companies in the world that is not covered by this bill, it seems. They've got a function in their software in Microsoft Word called Ideas in Word. It's a tool that urges users to avoid language that Microsoft dislikes and instead to adopt language Microsoft considers to be appropriate and politically correct. So how is it that one of these billion-dollar tech companies, seemingly $2 trillion, is not covered by this bill? We're supposed to believe that we are here rewriting antitrust laws to protect the little guy from these dangerous big companies. And I just came into possession of a document that everybody needs to know about. It's marked Confidential Microsoft. Whistleblower provided this. It's the first draft of one of these bills that would have covered Microsoft. This begs the question, did Microsoft have this bill and the other bills that we are voting on today before I had this bill? Why would you have to mark it Confidential Microsoft if they found it on the website for Congress? Why would it have to be marked this way? And so, okay, they're going to be affected. Maybe they need to know this is coming. I don't know why they would need to know it before me. But isn't it strange that one of the biggest changes in this bill, and it's particular not just to one of the bills, but several of the bills today, the bills were going to cover anybody that has at least 500,000 United States-based monthly active users. But now the threshold, maybe the author of this bill can explain to me why the threshold was moved from 500,000 to 50 million. Is there a single tech company that meets every other definition of this bill that would have been covered that is no longer covered because of this change except for Microsoft? And were they given an advanced copy of this bill? Why am I holding the first copy of this bill that says Confidential Microsoft and it came from Microsoft? Could somebody answer that question?
Gentleman yield back.
Well, I would like to yield time to anybody, maybe the author of the bill could explain, or the broad swath of bills, why this change was made and why it seemingly only affects Microsoft, none of the other big tech companies. And did Microsoft have a copy of this bill before I had a copy? I'd gladly yield.
Well, I'd like my own time. There's only 54 seconds left, so.
All right. Well, I'll be interested to hear that. I would like to respond to it. Maybe we'll get some more time later.
Would the gentleman make a copy of that available to the rest of us?
It will be, the staff, I hope, can distribute a copy of this.
I thank the gentleman.
Thank you. And if nobody wants to answer that question, I will yield back.
The gentleman yields back. Mr. Swalwell.
Thank you, Chairman, and thank you to my colleague, Ms. Scanlon of Pennsylvania, allowing users to carry data between applications and platforms, which is known as portability, and ensuring that applications and platforms work with each other, known as interoperability, are good principles. But I think what we are seeing is that interoperability especially can be a hornet's nest. And so having thousands of companies in my districts and 5-digit number of employees, thousands of employees who work at these companies, from 1 to 2 employees up to companies that have thousands at their workforce. I have sought to understand what each of these bills would mean for them. And so I've got just a couple of concerns, and I hope that my colleagues could sort out some of these. And I think Ms. Lofgren seeks to address some of them in her amendments. First, with scope. again, I'm for interoperability and portability, but why would we not want any tech company to be required to have interoperability and portability? And I think Ms. Lofgren made the point earlier about Zoom and some other smaller companies that are widely used but may not meet the tech giant criteria that are here. And so I do think if we are really looking out for consumers, we would want to make sure that interoperability and portability was required everywhere. As it relates to consent, I do have concerns that under the bill, it would involve third-party access to data, as Ms. Lofgren pointed out. I do think we need to protect privacy and user data control and give the user an ability to consent to the use of third-party access to data. I'm really concerned about China, and if this bill would require a US company to be interoperable with a Chinese company, and we all can imagine the dangers if the Chinese government has access to US person data, particularly people who work in the government or work at companies that have valuable trade secrets. I am wondering about GDPR and if any of this would violate GDPR, considering that most of the companies contemplated here are international companies, and we would hate to set American companies up to not be competitive overseas. On the issue of security, there are security and privacy standards for interoperability, but not for portability. And I think Ms. Lofgren is going to address this, but I have a concern about that. And then as it relates to API platforms, this would allow the FTC, this would require the FTC to be involved in API platforms and approving API platforms before any anti-competitive allegation is made. And again, it just concerns me that you would have to go through the government if you are creating an application and get approval from the government rather than commit a violation and then have the government say that it is a violation. Again, I think that would slow innovation and make us less competitive, particularly to China. So those are my questions and concerns. I think we're going to sort some of this out with Ms. Lofgren's amendments. Again, I thank the gentlelady from Pennsylvania for wanting to take this on. As I said, that this is a very challenging area, and she has worked very hard to try and take it on, and I hope we can find a way to sort out some of these issues. And I yield back.
Mr. Chairman.
The gentleman yields back who seeks recognition.
Mr. Chairman.
The gentleman from Ohio.
Thank you, Mr. Chairman. Move to strike last word.
Gentleman is recognized.
If what the gentleman from Kentucky just told us is accurate, think about this. We got bills that are supposed to go after big tech being written by big tech. Oh, and remember this, the secret committees, Microsoft will get to sit on those secret committees because you have to have a competitor on those committees. So they get to weigh in on the front end on how the bill's written. They get to sit in on the secret committees that aren't subject to the Federal Advisory Committee Act and weigh in with what the technical committee will then advise the FTC to do. And the FTC is supposed to do what under this legislation? Strongly take into consideration what the technical committee tells them. Wow. This is amazing. This is amazing. Now, again, we don't know if this is a whistleblower brought this information, or somehow Mr. Massey got it, but that is amazing. That's what we have here. Bills that supposedly go after big tech being written by big tech, the same big tech who can sit on the secret technical committees advising the FTC who says we should use antitrust law for all kinds of things. Wow. We're going to pass this stuff. When what we want to deal with is the censorship of conservatives. That's what we want to focus. That's what our constituents care about. It's amazing. This is amazing. I'll yield to anyone who wants to talk, but on our side. But I'll yield to Mr. Ice.
You know, Ranking Member Jordan, I share your concern that we really cannot answer the question except that there's no reason, and I don't believe anyone at Microsoft would believe, that a $2 trillion company that is one of only two in existence, with more customers worldwide than virtually any company in the history of our planet, would be exempt from this. So I do agree with you that there is a concern that all of us need to ask, and I know Ms. Lofgren is going to be dealing with some of this later. this committee needs to seriously consider whether this is a bill of attainder, whether or not we have narrowed it artificially to 4 companies, when in fact there should be 400 or 4,000 companies that potentially, in the case of this particular bill, okay, if interoperability needs to go from Facebook, Amazon, Apple, and Google, then doesn't it need to go from Alibaba back? On what basis would we have the dominant player in China and all over the rest of the world able to take from all 4 of these companies, but have no requirement to be interoperable back? You know, Mr. Owens has studied a lot of this, and we talk about it because he's supportive of the bill, but he talks about phones. But phones are interoperative both directions, every single phone. That's the way the system was designed. We are looking at 4 companies, not Microsoft, but only 4 companies that would have to give up their jewels, give up information to make their product send, but not receive back. So I would say that that this is ill-conceived with Microsoft out of it. I think Microsoft knows that. And I think that all of us need to ask the question of, are we looking at too few companies, particularly when it comes to interoperability and portability? I don't think that any of us think that if we're on a different platform, if instead of Gmail, I'm on Hotmail, that somehow there shouldn't be any interoperability because, quote, Hotmail, which might have almost as many users, or Microsoft Outlook, but there's no interoperability requirement because they're not covered. I think that's a valid point, and I think that what the gentleman from Kentucky showed us should cause us all to pause, maybe even pause on this markup until we know more. And I yield back.
I yield to the gentleman.
Yields back.
I yield to the gentleman. Last 40 seconds. The gentleman from North Carolina.
Thank you, Mr.
Jordan's time.
I yield to the gentleman from North Carolina, Mr. Bishop.
Thank you, the gentleman from Ohio. One of the things that's interesting about where we are is we're marking up these bills within a week or so after they've emerged, and I understood the reason for that, and I don't know if I got it explicitly or implicitly or read it somewhere, was because the concern that once they're out there, the big tech companies would be shooting at them and trying to shoot them down. But this development that Mr. Massey reveals would suggest they've had the bills, or at least one of them's had the bills in advance anyway. So why not take the time to have hearings on the bills and develop them fully and solve some of these problems about what interoperability means and the like, rather than do this on the fly? I yield back.
Gentleman yields back. For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word.
Gentleman is recognized.
I want to begin, Mr. Chairman, by thanking the gentlelady from California for working with me, and our staffs have been working together on this privacy issue, and someone who has been such a champion of privacy, and I'm confident that we're going to get to a good place on that, and really appreciate her suggestions to make some amendments that I think will improve the bill. But I want to say first, very clearly, throughout this process, and this was an investigation that was conducted for 16 months, there are no exemptions in these bills. 0. No company is exempted, period. Each of these bills is broadly applicable to firms that meet a definition for covered platform. That's a determination made by the enforcement agencies. So no one on this committee can make that determination. We had an investigation which focused on 4 companies in particular, but there's a criteria that's not company-specific. The 3 things are, is the online platform owned or controlled by a parent company that has a market capitalization in excess of $600 billion? 2, does the online platform have at least 50 million US-based monthly active users or 100,000 monthly active business users? And 3, is the platform a critical trading partner, meaning an online platform that has gatekeeper power or the ability to restrict or impede access to users or a tool that businesses need to effectively serve their users or consumers? That's the definition. There are no exemptions.
Would the gentleman...
No, I'm not done. And whether or not a particular company is covered or not is determined by whether or not they meet that standard, period. And so I want to thank Ms. Scanlon again, because this legislation acknowledges these competition problems online, develops a competition-based solution that's narrow and targeted, so there aren't unintended consequences. And we have had 3 hearings on remedies specifically after the committee approved the report that provided testimony with respect to each of these bills that are before us. So this is a 2.5-year process. And while there will be more opportunities to continue to think about these issues, this is a bill that, by the way, was introduced in the last Congress. So you don't have to be a detective to have found a copy of it. It was introduced by national security hawk Mark Warner. And so this idea of portability and interoperability is not a new one. It's been out there for 2 years. And so this is a very specific definition. There are no exemptions. There's no mystery here. This is a bill that was previously been introduced, and I urge my colleagues to support it. And with that, I yield back.
The gentleman yields back. There are a series of votes on the floor. The committee will stand in recess till the end of those votes.